My name's Tim Hurd from UK Legal, and I'd like to take a few minutes to talk about estate planning, and particularly two aspects. Firstly, making a will, and secondly, making a lasting power of attorney. Now, this is for information purposes only, but if you'd like to contact one of our consultants in your local area, then you can get specific legal advice for your situation. So let's talk about making a will. Well, it's quite startling that 68% of people have not made a will, and if you die without making a will, you die what they call intestate. It simply means you have no input in how your estate is going to be established, how it's going to be paid out. Now, I'm not going to talk in great detail about that, and the reason is the very fact that you're listening to me suggests you're likely to make a will. But if you die without a will, the one thing you cannot assume is that if you die and you're married, your husband and wife will get everything that you own. You cannot assume that. So it's important that you make a will. Now, I'm going to talk about a couple of scenarios, a couple of types of wills. Now, there are a lot of different scenarios and there are a lot of different options, and that's why it's important that someone sits down with you and goes through your particular situation. But let's look at a couple of situations that might surprise you. So we're going to look at a family, we're going to look at John, and John is married to Mary. Neither of them have been married before, and they have 2 children between them. So let's have a look at a basic will. So what John wants to do is wants to leave everything to Mary and vice versa, and when they've both passed away, everything goes to the children and then down the bloodline. Now, on the face of it, that doesn't seem to be a problem. Let's just look at that. So let's say John dies. Now, John and Mary own a house and they've got some money in the bank, and John dies and he passes everything to Mary. Now, Mary lives for a further 35 years, and during that time, after about 5 years, she meets Tom. They get married, it doesn't work out, and they get divorced. And Tom, in the divorce settlement, gets half the house, the very half that John thought would pass to his children. And other things can happen. Mary could get into financial trouble and go bankrupt. And because John gave the house to Mary, then the creditors can take it. And of course, as she gets older, if she goes into care, because she owns the whole property, then the whole property can be used to pay for care costs when she passes away. And the crying shame is none of that needs to happen. You see, with correct estate planning, what John could have done is he could have had a will with a property trust in it, and within the property trust, a right to reside. So the first thing that he's going to do is not pass the house or his half to Mary. Now, the first thing Mary's going to say is, well, hang on, where am I going to live? Well, she has a right to live in the house for the rest of her life. She can move, but she doesn't own that half. That half is owned by the children on the demise of Mary. So now let's see how that would work out. So as we've said, Mary lives another 35 years. She meets Tom. They get married, they get divorced, but now Tom can't take John's half of the house. It's owned by the children in trust. It's not an asset of Mary, and therefore it's guaranteed to go to the children. And it would be the same if Mary went bankrupt. She doesn't own that half, therefore it can't be lost. And if she went into care, when she passed away, they couldn't reclaim care costs from John's half because it's owned by the children. It was never owned by Mary. So can you see the tremendous advantages of putting in estate planning? Now, 5 years before John died, he had a stroke, and it was a bad time for the family. Tremendous stress, because they'd lost an income, John's income. He couldn't get up the stairs, and therefore Mary had to sell the house and had to rearrange finances. And she couldn't do any of that because she had no authority to act on John's behalf, not in terms of financial questions or looking after him in terms of health and welfare. Her only route was to go to the Court of Protection, which was very expensive and very stressful, and again it could have all been avoided had John had estate planning in place. So what could have John done? Well, while John was healthy, he could have put in place a lasting power of attorney, one for his finances and one for his health and welfare. It's likely that he would choose maybe as his attorneys Mary and maybe the two children. So now when John had a stroke, then the children or Mary could deal with all of his finances and make on his behalf decisions about his health and welfare. All of the expense and all of the stress would have been avoided, providing the lasting powers of attorney were registered while John was healthy, which is something that we would automatically do for our clients. So can you see the tremendous advantages of having these steps in place, both in terms of asset protection and also in terms of looking after your family and loved ones? What I'd encourage you to do now is to take some action, because one of the things about the fact that 68% of people haven't made wills is because whilst they have the information readily at hand, they don't do anything with it. So if you'd like to take some action now, through our website, arrange for one of our consultants, wherever you are in the country, to come and visit you. That consultant will come and visit you in the comfort of your own home. We'll go through particular estate planning as far as your situation is concerned. It's a completely free of charge service and there is no obligation.